we have the Anglo-Saxon common law system with the principle of caveat emptor. I think you may have caveat emptor too, but
in fact, it's Roman law.
it is Roman law.
So it's
buyer beware. But I think what my civil law friends say is, how come Anglo-Saxon sale and purchase agreements are 150 pages, whereas a Dutch sale and purchase agreement will be 20 pages? Because
maybe they say they're brighter? Or?
No, I don't, well, they do say that they're brighter, but they also say a lot of the stuff is covered by civil law. It doesn't need to be restated, especially stuff related to employees, warranties related to property, warranties relating to pensions. All the stuff is covered by the law, whereas in the common law system we put it all in the contract. So ours are inevitably longer. What's it like with you guys? Because you're
we have in Quebec in a very hybrid system.
Yeah.
I would say a strange system.
Yeah.
It's like a camel with a horse head, or the contrary, or a horse with a camel head.
Yeah.
It's very, because if we go back to the history,
Yeah.
In Quebec, in Canada, in fact, was a French colony until 1760.
All of Canada?
But at the time, Canada, in fact, it's very interesting because New France was half of the North America.
Yeah.
It comes from Quebec City, Montreal, you go down the Mississippi,
Oh, right,
to New Orleans. It was,
Louisiana and all that.
Louisiana,
Yeah.
Louisiana also has a dual system of civil law, as we have. But for us, it's more entrenched into the system of laws. So, we have you know that in 1774 we had a law. We call it the Act de Québec, Act of Quebec. At that time, the British were worried because there were like problem with the American colonies, and they're like Canadian colony, British North America colony. Yeah. They just won over the French at that time. So they decided to give some candies to the population there to keep them quiet. The most important thing at the time was the religion. Yeah, Catholicism. Not the language, the religion, and the legal system, curiously enough. Yeah. So it's why we have a civil law in Quebec, but the civil law is among the people. And the British were and were kind of wise to say, yes, that's fine among yourself, you keep civil law, but anything that has to do with the state and the individual and criminal law has to be common law. So our criminal code is very much like your criminal code. And the system is very much the same. It's not the French system that we have. So to go back in commercial law, contracts. So we have a dual system. So we have also 100-page documents for SPAs and APAs. And we rely also to the Civil Code, Civil Code of Quebec. Civil Code of Quebec has been inspired of the French Napoleonic Code. Yeah. There are kind of difference, but the basis is quite the same. So each time we do the contract, we rely on both. But there are occasions that, as you know, in civil law, just finish on that. Yeah. As you know, in civil law, we have certain sections that are of public order. Yeah. So even though we write it in the contracts, you cannot contravene to the sections that are of public orders. For instance, you could revoke a mandate at any time, even though you write it. All right. Or you have anything that has commercial renting. There are a lot of documents of public order, family law, many things. Yeah. So we have to look and be aware of the civil code and the practice. But do not forget also that Quebec is a very small way, like 8-9 million people. It's not so small. But compared to the North American market, yes. Yes.